Now, it's my great pleasure. Both our panelists today are very long-time friends and colleagues of mine, so I'm not a completely unbiased chair, but it's my great privilege first to introduce my graduate student, Darinka Tomic. Darinka has many years of professional experience as a legislative librarian with the Ontario Legislature and has come to the study of intellectual property areas and connected areas in our graduate program in the Faculty of Law at the University of Western Ontario, but has an extensive background early in her education in philosophy. So without further ado, I will introduce my colleague, Darinka Tomic.
Thank you very much. This is a great privilege to be here as a graduate student and present to you my work in progress. So this is just an upfront note that this is a work in progress about my research. But the theme about this conference is challenging intellectual property was quite intriguing, and I really tried my best to adjust to it, to adhere to it. And when my research work is about intellectual property and the right to food. And how I came up with was, again, thanks to Professor Wilkinson, who actually reminded me that we had at Western Law a fabulous opportunity that visiting Professor Graham Austin from New Zealand came to teach an intensive course, and that I should enroll in it, and I did. And it was based on the book he authored also with Lawrence Helfer, and it was about human rights and intellectual property. And then I read that book and I attended that course, and a chapter of his book, chapter 6, was about intellectual property and the human right to food. And it really started me thinking about this topic and what is the relationship and why, how on earth we can talk about the right to food, particularly in the 21st century, but there is a lot to say about it, and this is, I believe, that I might point to some of the interesting aspects of it in my presentation. I will start by quoting an article of Lawrence Helfer titled "Human Rights and Intellectual Property, Conflict or Coexistence." So, and he said in his article, that was published in 2003, the lawmaking underway in these fora reveals two distinct conceptual approaches to the human rights intellectual property interface. And I stopped right there and I said, what interface between human rights and intellectual property? Isn't intellectual property a human right? So those two aspects that he identified were, number one, human rights and intellectual property as being in fundamental conflict, strong intellectual protection undermining broad spectrum of human rights obligations. And he offered that resolving it, the proponents asked for normative supremacy over human rights law, over IP law in areas of conflict. And again, it made me think, is there really a conflict among the intellectual property and the human rights? So, and the second standing or approach and thoughts he presented in his article was that human rights law and intellectual property law seen as essentially compatible, although the fundamental question remains in finding the balance, defining the scope of private monopoly power that gives authors and inventors a sufficient incentive to create while ensuring that the public has adequate access. So it's between those two aspects or two ways of thinking or in scholarship, I started thinking and asking myself the questions that I put on the right side of this. And are human rights and intellectual property really in conflict? So that word was something that I was intrigued by. So is there really conflict? Or is there a competition then among the human rights, considering that intellectual property is declared a human right? Finding the definition of rights fundamental, I found like closest to my approach and my way of thinking. What happened with intellectual property then? The crossing of the line, that intellectual property being a human right crossed that line to international trade in 1995 with the World Trade Organization. And it crossed that line only partly from human rights to international trade in 1995, but also remained very strong in the human rights arena. And I think that is probably some beginning of those aspects of conflict, or identified as conflict in scholarship. So we have a stronghold of the World Intellectual Property Organization, that is an agency of the United Nations, then that means being a part in the human rights arena. And then we have a TRIPS agreement that is actually agreement on trade-related aspects of intellectual property that partly included intellectual property into the international trade and gave the intellectual property that power of trade. So this is where probably lies some of the aspects of the conflict identified in the scholarship. Okay. Then I just put it together into those two tables. On the kind of my blue, like a color-coded side, is a human rights side, the green one being in the international trade, I think for some obvious reasons, not need to explain. So what happened in 1995 is that Paris Convention, Berne Convention, Rome Convention, Treaty on Intellectual Property in respect of integrated circuits, they actually were the one who crossed the line into World Trade Organization. Annex 1C, the Agreement on Trade-Related Aspects of Intellectual Property, since its inception in 1995. And Article 2 of the TRIPS agreement says that intellectual property conventions incorporates countries' obligations under various WIPO treaties up to 95 and gives countries the power of trade law, in addition to their participation in public international law. However, at the same time, the WIPO organization has been very active, and it actually did create even some new IP rights, like in 1996. The WIPO Copyright Treaty and the WIPO Performances and the Phonograms Treaty were passed, creating those new rights. Okay. Now, my focus of my research is the right to intellectual property versus the right to food, and why I will explain further. Intellectual property is, as explained so far, currently omnipresent in both public international law and international trade, while the right to food has a much lower profile. And my work looks at how the right to food can best become more prominent on the international agenda. While I'm thinking about this, and when I was thinking along those lines with the conflict among those rights, I wanted to present it in some, graphical way, and I was thinking about this Aesopian old ancient fable between the race between a slow-moving tortoise and a fast-running hare. And I thought, well, that I might use those characters to just, show whether there is a race and what kind of race that might be between the right to intellectual property and the right to food. And I didn't infringe the copyright because those drawings are mine. The agenda of my presentation here is about the human rights arena, about the merging of the right to food and the right to intellectual property as human rights. Intellectual property, I will use a little bit of a historical view here, talking from the 19th century conventions to entrance into modern international trade. And international trade arena, the tension with human rights since IP entered trade, so TRIPS agreement, of finding the balance. I will use two agreements. One is the Doha Declaration that occurred in the trade arena, and the Marrakesh Treaty that happened in a WIPO, human rights arena. And I will probably not come up today with any conclusion about where the right to food will go, but I'll keep it open and ask what direction this might take. Going to now some basic explanations, what and when the food was articulated as a human right. Food is a tangible good, as we know, and has been traded since long before the establishment of any national boundaries and the introduction of tariffs in trade. It doesn't require any definition, I believe. But the right to food is a different concept, it's a different idea, it's an intangible as a right. And it was recognized as a human right in the Universal Declaration of Human Rights in 1948. And of course, as a right in a document of this proportion requires a definition. Similarly, intellectual property became a human right, which I believe sometimes is not emphasized enough in the scholarship. Intellectual property is intangible and did not exist until the Industrial Revolution. The 19th century agreements to harmonize economic monopolies for inventions, Paris Convention in 1883 and literary and artistic works, Berne Convention in 1886. But they were updated and revised several times up to this day. And I'm just going to mention one revision which I believe was important for identifying intellectual property as human right. And this was the first recognition of moral rights in a Berne Convention Rome revision of 1928. But the right to intellectual property is intangible, and it was again recognized as a human right in the Universal Declaration of Human Rights in 1948, the same time as the right to food. With that crossing of the line that I showed you previously, that intellectual property made in 1995 to international trade arena, we kind of have changed a little bit of that aspect of it. We may refer then with the power of trade it was given to intellectual property that it obtains quasi-tangible quality, and that is only temporary. It is only for the period of the existence of the monopoly of the right. I would like to give a credit to the person who created the first draft of Universal Declaration of Human Rights, John Humphrey, the Canadian law professor, and the creator of the first draft of the Universal Declaration, and he observed that politics nevertheless played a secondary role in the early years, and by United Nations standards, the Commission performed its mandate well. That's a quotation from his own book, Human Rights and the United Nations, A Great Adventure. And that's a sort of a memoir, but it gives a really very valuable information about, I'm free here to say, a very political situation that happened after the Second World War and during the work of the Commission who were drafting the Universal Declaration of Human Rights. My research will include several other human rights, not just intellectual property and the right to food, but the right to freedom of expression in the Universal Declaration of Human Rights, also from 1948. And I will read this Article 19. Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. And why I'm citing this article? Because it is relevant to Article 21, freedom of expression and access to information right in the UN Convention on the Rights of Persons with Disabilities that was adopted in 2008. Actually, it was created in 2006, but it took a couple of years before it was adopted finally in 2008. And why I'm mentioning this, you will just see. Emerging rights in the Universal Declaration of Human Rights in Article 4, the right to food. In Article 25.1, it says everyone has the right to a standard of living adequate for the health and well-being of himself and of his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his control. I'm citing this complete article because we are talking about the right to food, but the right to food is here only mentioned as a part of the standard of living adequate for the health, and the health being number one. So I highlighted in various colors those rights that I'm discussing in my work: the health, food, disability, and the right to intellectual property. the right to intellectual property being cited as Article 27.2. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. I just want to stop here, pause and say, no, the term intellectual property is not used in the Universal Declaration of Human Rights. That is something that is in my work. I am discussing the definitions, the articulation of the rights, because I do believe that this is what we even heard during this conference, and particularly the symposium with Professor David. We were talking about these definitions, and those definitions sometimes are not clear, are not actually matching the right that we are discussing. We talk about intellectual property as right all the time, but intellectual property as a term does not exist until 1995, TRIPS agreement. Here I will go a little bit further. You know, the Universal Declaration of Human Rights was a huge accomplishment and a great authoritative document, but it's not a binding document, it's not a treaty, and we needed a document that will be more binding the nations, member nations worldwide. So although the Universal Declaration of Human Rights does not have a separation among the rights, they are based on this principle of universality, so there is no distinction between the various categories, there's no any kind of a structural division among them, although the discussion in a preliminary, in the preparation for the Universal Declaration of Human Rights did include a lot of discussion about civil political rights in comparison to the economic, social, and cultural rights. So in 1966, we have two covenants. One is International Covenant on Civil and Political Rights, and the other International Covenant on Economic, Social, and Cultural Rights. And you can see here this division where all the rights that I am talking about now came under. So in the International Covenant on Economic, Social, and Cultural Rights, we have a huge development, and I think it was for the right to health, which was separate, which now in the covenant received its own provision, Article 12. The states parties to the present covenant recognize the right to everyone to the enjoyment of the highest attainable standard of physical and mental health. While the right to food remained in this conglomerate provision, as now Article 11, where the state parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family, including adequate food. So now we have an attribute, adequate food, clothing and housing and so on. But the new development is this paragraph 2, which says of the same Article 11, the state parties to the present covenant recognizing the fundamental right of everyone to be free from hunger. So it's almost like introducing another new right. There is a distinction. I'm not, in my limited time here, I'm not going to get into these details, but I discuss it in my work, in my research, about the distinction between the right to food and the right to be free from hunger. So the right to intellectual property, what happened with it, it is almost like the text is in the covenant almost the same as in the Universal Declaration of Human Rights. It is again the benefit from the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Again, it does not include term intellectual property. What happened with the freedom of expression? That right is now under the covenant of civil and political rights, and Article 19.2, everyone shall have the right to freedom of expression. This right should include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either oral in writing or in print in the form of art or through any other media of his choice. And I'm citing it because it will be relevant to the treaty that I will discuss further in my research. But note that the right to health received separate provision in the International Covenant on Economic, Social, and Cultural Rights, while there is no mention of the rights of persons with disabilities. What is happening on the side of international trade? Again, it was discussed heavily at the same time when the Universal Declaration of Human Rights was drafted or created. But then it couldn't get into it, although there was some thoughts about the politicians that it should be included. But the 23 nations agreed to sign a general agreement on trades and tariffs at the same time in 1947, and it entered into force in 1948. But there is no mentioning of any of the human rights in that agreement. So freedom of expression, nor right to protection of moral and material interests, right to standard of living for health, including food, and the right to security in the event of disability. The further development on the international trade side was the World Trade Organization, established in 1994, where the agreement on trade-related aspects of intellectual property rights entered into force in 1995. Intellectual property appeared in the title of those treaties, as well as it appeared in the title of the World Intellectual Property Organization, but not as an article, not as a provision at law. Intellectual property gains its place in international trade as well as in human rights law with the establishment of the World Trade Organization. Then we have a pressure from social groups and various NGOs on UN human rights institutional mechanisms, because they recognize that human rights should take supremacy over trade. Now we're getting back to the article that I cited at the beginning of my presentation. So is there a human right that should have a supremacy, and over which one? So Intellectual Property Rights and Human Rights Subcommission Human Rights Resolution 2000 declares, however, that since the implementation of the TRIPS agreement does not adequately reflect the fundamental nature and indivisibility of all human rights, including the right of everyone to enjoy the benefits of scientific progress and its applications, the right to health, the right to food, and the right to self-determination are apparent conflicts between the intellectual property rights regime embodied in the TRIPS agreement on the one hand and the international human law on the other. And then at the same time, this resolution says it reminds all governments at the paragraph 3 of the primacy of human rights obligations over economic policies and agreements. And I believe, based on this resolution, that some of the scholarship was very much interested in and then used those terms in creating the articles that were now resonating, the conflict, supremacy, and in some way sort of a competition among the human rights. Now this is like, I know there's lots of information here, but it's literally, this is a kind of a summary of what I was talking so far about. And just reminded you of the articles that I'm dealing with and the rights that I'm dealing in my research: freedom of expression, right to health, right to food, and the right to intellectual property. The situation about crossing the line of the intellectual property into the World Trade Organization in 1995, and the reaction that occurred based on this crossing of the line, based on the huge pressure of the non-governmental organization and various social groups on the United Nations. This resulted, and of course on the World Trade Organization, it resulted in those two treaties here that I will like to discuss in my research, and one of them being a Doha Declaration on TRIPS Agreement and Public Health, which was a huge, I think, a victory of the human right to health, but it is also, I think, as a result of right to health being separated and having it received in the International Covenant its own provision. And the second one is happening in the human rights arena, and that is the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. This is the first users' rights treaty ratified on the 30th of June 2016 and entered into force 30th September 2016. And that one is again associated with the right of persons with disabilities, and I'm referring it here to the Convention of the Rights of Persons with Disabilities, and the freedom of expression and opinion and access to information. What happens with the right to food? It's kind of left out. It's there, and the only mechanism that actually deals with the right to food is the special procedures, the special rapporteur on the right to food that was established in the year 2000. I would like to just not discuss in detail, but show you about the Doha Declaration on the World Trade Organization website. We can find a lot of information there. And Doha Declaration on the TRIPS Agreement and the Public Health in 2001. And further talking about the implementing of the Doha Declaration is not easy. It was a huge kind of victory for the right to health, particularly for the public health in the trade, international trade arena. However, I'm just going to show you here this case, the Rwanda-Canada case in 2007, which again took several years from the moment of the Doha Declaration to the first delivery of the drugs that were actually manufactured by Apotex. So this was, again, I think the only case that the Doha Declaration was put into the test and into the practice, and how, regardless of how the treaty can be very beneficial for the humanity or humankind, the implementation of it might take years. I don't have much more time to. I'm just going to point what happened on the world intellectual property side and the human rights arena, and the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. And I'm going to cite this Professor Elkison, who said that there is no question that Marrakesh is historic because it is the first international treaty focused on users' rights and copyright. Its adoption certainly dispels any argument that the treaty on exceptions and limitations to copyright holders' economic rights is not possible. Just a few more points. The Marrakesh Treaty has no connection to trade. Marrakesh Treaty, although based on copyright limitations and exceptions included in TRIPS, has been solely developed in the human rights arena, in the WIPO. And it's based on those articles that I'm citing here. So what happens with the right to food? The pressure from social groups and NGOs on the UN human rights institutional mechanism, the right to food, led us to the general comment number 12 about the right to adequate food from the International Covenant on Economic, Social and Cultural Rights. And its preparation was triggered by the request of member states during the 1996 World Food Summit for a better definition of the rights related to food. And I'm highlighting this, and I'm again going back to the article that I cited at the beginning about the fundamental requirement for a better definition of the rights. Okay, just two more. A major turning point for the right to food was what I mentioned, was establishment of the special mechanism, was the special rapporteur of the right to food. However, the special rapporteur is an individual, is an expert, and this is just a person who provides very valuable insight, but an expert opinion. And that opinion does not have a power of a treaty, or doesn't have a power of law in any way, but it is extremely helpful, although it may lead sometimes in a somewhat, instead of a better word, wrong direction. So my research question about my work is, would the right to food be better advanced if presented in terms of becoming the basis of text toward a Marrakesh-type treaty through an UN agency, that means in a human rights arena, or as a Doha-type declaration limiting interpretation of private rights in the international trade context. Some of the most important sources that have been used are cited here, and this is my kind of final, well, I'm right on time. So crossing the finish line, so this I think tells all what I wanted to say to you today, and thank you very much for your attention.